Hello, this is John Milburn. We're into week 10. This is the environmental law series, and tonight we're dealing with enforcement issues, primarily criminal law, but when it comes to enforcement of environmental laws by regulators, there are a number of means. So initially, regulators should consider administrative remedies. They could also consider civil remedies.
John,
Yes, John?
I noticed in this week's work, there were no lectures. There was the Word document that you put in for this week's thing, where you go through 1,000 cases of different judges giving penalties, but there was nothing else.
That's right. So this is it. This is the combined lecture tutorial tonight. But you're right. No, there is nothing else.
So it got me that it's fine that they're actually able to give penalties if people do the wrong thing, but it's like it's too late then.
Which actually, that's a really good point. That's an excellent point, because you've identified that criminal law proceedings are reactive. Now, they're not proactive. And as a result of that, regulators need to consider criminal prosecution, but probably as a last resort, and then the imposition by a court of an actual term of imprisonment, if you like, a last resort of the last resort. I'm not saying that regulators must always consider the alternatives of administrative remedies or civil remedies or seeking enforceable undertakings, but criminal enforcement is something that is not embarked upon lightly, and there are some very clear processes that are apply to criminal prosecution, and there's the issues in relation to enforcement of warrants, etc. Now, my internet connection is said to be unstable, so I do apologise if my voice is starting to distort. All right, so, yes, John?
Yes, your voice is distorting.
And to be honest, I don't know what to do about it yet, but we'll work on my internet connection here in my chambers.
What we'll do is next year, when you get the NBN, don't just take it like all us poor plebs that have to take the last 50, 100 metres with a copper cable. Somebody with the money would be smart in putting optic fibre cable to their house.
Thank you very much for that tip. Okay.
Yeah, well, most of us can't afford that.
Well, we'll see how we go, but thank you, John. All right, so we've identified at this stage that regulators have three broad alternatives: administrative remedies, civil remedies, or criminal prosecution. And the administrative remedies are subject to the right of challenge, and we've talked about the opportunity for aggrieved people who receive an administrative remedy to seek judicial review or perhaps a merits review proceedings. Civil law gives regulators an opportunity to take civil action, and that can be in many ways a greater penalty imposed in real terms, in dollar terms, than can be the case in relation to criminal proceedings. So bear in mind that there are those options. Now, in terms of civil law generally, or administrative proceedings, that they can take the form of notices, or they can be the form of compliance plans, damages, injunctions, environmental audits. So there's a range of opportunities that are available to regulators beyond the criminal law, and it's a matter of looking at the regulatory documents that deal with the planning instruments and also statutes that provide opportunities in that regard. But let's say we've got to the stage where the regulator has determined that an appropriate course of action is criminal proceedings. The first thing to do is consider the classification of offences, and there are a number of different ways to categorise offences generally and specifically in relation to environmental law. There are a number of things that you need to consider in terms of privileges and defences that are available to defendants or people that are suspected of breaching environmental laws. There are special rules that apply to corporate liability. There are special corporate defences. And then finally, if there is a successful prosecution, there are issues to do with sentencing. And if an order is made of the court generally, whether it's in criminal proceedings or civil proceedings, there are issues that may be relevant regarding contempt of environmental laws. So there's a whole range of different categories that we need to consider tonight. There are also a range of statutes that are applicable, and when you're dealing with environmental issues, I think you should always be mindful of the fact of considering the statutory provisions at a very early stage, if not at the start. So what are the statutes? Well, when it comes to the Commonwealth level, think of the EPBCA, the Environment Protection and Biodiversity Conservation Act. That's pretty obvious. But also the Crimes Act may be relevant. At a Queensland level, the range of statutes, certainly as we speak, the Sustainable Planning Act, which is about to be superseded. There is, of course, the Environmental Protection Act, the Vegetation Management Act, the Building Act, and then when it comes to dealing with issues to do with defences and penalties and procedures, then it may be the more general acts such as the Criminal Code, the Penalties and Sentences Act, and the Uniform Civil Procedure Rules. You might think it's a bit odd that I'm talking about the Uniform Civil Procedure Rules. Yes, John?
That's the Queensland Criminal Code, isn't it?
The Queensland Criminal Code. But you're right, there is the Commonwealth Criminal Code as well. But I was referring specifically to the Queensland Criminal Code, which is 1899. The Criminal Code is actually scheduled to the Criminal Code Act of 1899, but it's very easy to find. Okay, so when we're talking about criminal...
So it's 1899.
Yes, 1899.
1899.
Amended many times since then. And the idea of a code is that it was intended to be an all-embracing statement of the law in relation to that particular topic. Of course, it's not. I mean, many criminal matters are dealt with by legislation other than the criminal code, but that was the original intent. All right, so what do criminal prosecutions involve? Well, firstly, it's a last resort process. It's reactive, as John pointed out at the start of our lecture. The proof needs to be beyond reasonable doubt, as opposed to the civil standard, which is on the balance of probabilities. And it is a case of reacting rather than necessarily preventing. So if you're faced as a regulator with a position where you need to do something to stop something occurring, then of course you'll look to civil remedies, perhaps injunctions, instead of dealing with criminal procedures. When it comes to the categories of offending, in short, there is a dichotomy between summary matters and indictable matters. There is a hybrid, which is indictable matters dealt with summarily. So that's one category difference. A second is that there are different categories of offences that depend on the element which are established in the offences, intent, for example, and some are referred to by the extent of harm caused. So in the Environmental Protection Act, there is a dichotomy between different offences that relate to the extent to which the harm is caused. So there's different ways to categorise offences, but the basic categorisation of offending behaviour is between summary matters and indictable matters. Okay, so what does that mean? Well, an indictment is really a document. It's a document prepared as a prosecutorial document where a prosecutor presents an indictment to a judge. That is something that really establishes or kickstarts, if you like, the procedures, the prosecution in the higher courts. A summary matter is something that's not an indictable matter. And there are different categories. There's regulatory offences as well, but for tonight's seminar, just for simplicity, I'm including those as summary offences. So a summary offence basically is one where a magistrate deals with issues of fact and law. An indictable offence that is dealt with by way of indictment on a plea of not guilty in a higher court is one where the jury decides facts and the court, the judge, will decide the law. There are some important practical differences. If it's a summary offence, which is generally a lower offence, less criminality, often there are time limits that apply, so be aware of that. 12 months is often imposed. So where we have differences relating to the nature of the offending behaviour, the first place to look is the statute. So, for example, in the Environmental Protection Act 1984 in Queensland, have a look at section 494, and it provides you with a clear indication of what is meant by indictable, what's meant by summary. Other legislation, such as the Vegetation Management Act, provides that all offences are dealt with summarily. And it also provides, as I mentioned before, that issue of proceeding within time. You must commence the proceedings under the Vegetation Management Act within 1 year of the commission of the offence or coming to the knowledge of the complainant. Yes, John?
It made me interested in the Vegetation Management Act, the VMA, where they changed it to being indictable to only being a summary offence.
Yes.
As so to make it not as a severe penalty for doing environmental damage.
Yes. And years ago in the offerings of this course, I would ask students to provide commentary in relation to that change, which I think occurred in about 2013. But I haven't been doing that for a couple of years now. But you're right.
That was Mr. Newman.
Yes, it was very controversial. That's why I included it in the assessment regime, because people had strong feelings about it.
Well, it's still the same with the tree clearing legislation. They changed it, and they can't change it back until there's enough people in Parliament to actually vote for stopping tree clearing.
Yes.
Because they changed in the Newman. Yeah. So tree clearing goes on.
Mm-hmm. Interesting comments. No, you're right, John. All right. So so far I've been talking about the different categories of offences within the context of criminal law. But remember, of course, that we have the Commonwealth and we have the state jurisdiction. So let's talk for a moment briefly about criminal law of the Commonwealth. Again, we look to the EPBCA, and the main point there is that breaches of certain Commonwealth environmental laws can be the subject of prosecution in circumstances where a person takes action that has some impact on the environment. So, for example, if that action is one that has a significant impact on a matter of national environmental significance, assuming, of course, that they don't have prior approval, then courts can impose a criminal penalty up to 7 years imprisonment or up to about $50,000 in penalty. That's actually...
Excuse me, John.
Yes, John?
Point of order, sorry. Have there actually been any cases? I don't remember in your commentary or anything about any case prosecuted under the EPBCA that was of note.
Actually, you're right. And I was just about to say, to my mind, those penalties are modest when we compare it to the state regime in terms of what might be imposed. But there is an Australian Government Department of Environment website, and that's worth having a look at in terms of some issues to do with compliance and enforcement mechanisms under the EPBCA. So I'd recommend that. Perhaps I could put that on UCREW.
Has anybody been prosecuted under the EPBCA Act? I mean, EPBCA. Are there any cases where they've run prosecutions?
I can't think of a good example at the moment. So I can't answer that question. I do trust that there has been, but honestly, you're right, John. I can't think of something immediately. But I'll have a look to see if I can come up with something. And you're right, I was concentrating in my notes on the state regime. So I mentioned the the EPBCA at the Commonwealth level, but I haven't looked into it. So as we speak, I'm just going to see if I can have a look at the website.
Sorry to put you on the spot.
Oh, no, it's good.
Sorry about that.
No, that's good. So what I'm doing...
Sorry about that.
No. I'm just looking to see if I can find something in the Australian Government Department of Environment website that might assist. But I will follow that up, John, because you're absolutely right. No, I'm not having much luck just at the moment. All right, so in a more general sense, if you are prosecuting a criminal matter or you're defending a criminal matter in an environmental sense, always have think about looking at the DPP guidelines, which are pretty valuable. Those DPP guidelines provide the basis upon which prosecutions are initiated, provides the basis upon which those prosecutions are continued, and from a defence perspective, provide you with opportunities to consider negotiating something that may assist you. Look, as I normally do, I'll see if I can share the screen and just give you a snapshot of the the DPP guidelines, and I'll do that now.
Once again, John, that's the Queensland Department of PP.
It is, yep. So most of the emphasis is on Queensland, and this is the ODPB, the DPP prosecution guidelines and directors' guidelines at a state level in Queensland. And the thing is, when I'm looking at this from a defence perspective, I'm trying to pick on the things that will allow me to negotiate or to otherwise deal with the case. So the DPP has obligations to be fair, expedient, to deal with matters in a certain way, to deal with them summarily if they can reasonably be dealt with summarily, and there's a whole lot of other issues that relate to all criminal prosecutions, but specifically can be used in our context for dealing with issues in the local sphere. I'll just stop the share now and we'll continue. So, and I will have a look for those EPBCA prosecutions. Yes, John?
Sorry. From an environmentalist perspective, this chasing people that have done the wrong thing really is sort of like, as we said, it's after the fact. The damage has been done. But I guess the only way you'd get some satisfaction if there was deterrence value, and environmental laws are fairly weak, even for prosecutions.
Well, yes, there is the issue of deterrence. Bear in mind that it is possible to initiate private prosecutions. So private prosecutions through legislation are possible for breaches of environmental law through the criminal law process, but that's rare if ever used. The other way is to approach the Attorney General and become involved that way. You can actually prosecute the Crown, and we've talked about that in the context of, say, Crowther's case, where there was a prosecution against well, not necessarily the Crown, but in that case, TAFE, through the government agency. All right, just bear in mind that sometimes, as I set out in the notes, intent can be an issue. It's an issue in terms of how to classify an offence by reference to intent. It's also an issue in terms of what needs to be established to secure a prosecution, and then ultimately the question of penalty. So if you need to establish intent and you're able to do that, then generally the penalties are greater. I mentioned that you need to look at the legislation. The Environmental Protection Act makes a distinction between material environmental harm, which is section 16, and serious environmental harm, which is section 17. And when you're looking at this from a defence perspective, you need to think about the words that are used and ask whether it's appropriate or proven that your client has, for example, in the case of a charge of material environmental harm, done something that is beyond trivial or negligible in nature or extent or context. So they're the words in section 16. Have a look at each of those if you're trying to defend an action, to argue that this prosecution doesn't fit within the category because it doesn't fit within the words. Or you can argue that the actions of your client don't cause the potential loss or damage that's being sustained, or results in costs that relate to taking action that is appropriate to remedy the breach or minimise the harm. So each of the words that are used are important there. When it comes to the distinction between... yes, John?
Sorry, we don't want to defend environmental damage.
You got to remember, of course, that I do defence work. So it's sort of near to my heart in terms of looking for ways that you can defend people in those circumstances.
So as once again, it's an environmental science subject. We're looking to stitch these people up.
Exactly. And look, I'll give you an exam tip. What I am keen to do is provide you with a scenario where you are not a lawyer, but you are faced with a situation where within, say a council, you see something that you think may be the subject of enforcement, and you see something that requires some action to be taken. And for example, the CEO may come to you and say, all right, this has come to our attention. What are the remedies that are available to us? What do we consider doing? And, how do we brief lawyers appropriately if we need to get lawyers involved? So I guess if you're in that situation and you see something... Yes, John?
So this is a council person that's seeing a possible development. Is that what you're saying?
Look, it might be. It may be a prospective development. It might be that someone's taking some inappropriate action without authority, or it may be that someone has not complied with conditions of an approval. So all of those are circumstances where you might think as a regulator, all right, it's all very well having read Bates's book, now I've got to do something about it. What can I do to remedy this situation? Do I look at administrative remedies? Do I look at civil remedies? Do I look at criminal prosecutions? What's the basis for arguing each one of those? What's the legislation I need to consider? And how do I go about properly briefing lawyers to take action? So that's a bit of an exam hint, John. All right, so if you're looking at...
You're breaking up. In fact, you've broken up. You've stopped.
Stop. Can you hear me now? I just saw the sign, the internet stable and unstable. Can you hear me, John? All right, I do hope that I haven't lost this session completely. All right, well, I'll continue with the session, and the defences that might be available are honest and reasonable mistake of fact, Section 24 of the Criminal Code, Section 25, emergency, and if you're dealing with a corporation, have a look at, or even an individual, have a look at Section 319 of the Environmental Protection Act. Another defence potentially is Section 493 of the Environmental Protection Act. Otherwise, think about contempt proceedings. Have a look at Section 439 of the Sustainable Planning Act in that regard, and I've given some cases by way of example in the notes. I've also given you some idea of the issue of punishment. You may need to consider the question of warrants, and there are some issues to do with how to go about obtaining warrants under the Environmental Protection Act, and how, to what extent officers can deal with those issues of warrants. Have a look at the Link Energy case, which is the CEO of the EPA. Now it looks like we've got John back. Have a look at the case of the CEO of the EPA against Link Energy, which is 2015 QCA 197. When it comes to sentencing, the general place to look is Section 9 of the Penalties and Sentences Act. Have that section handy for the examination, which of course it's a take-home exam, but for 11046. Have a look at some other more specific examples of where prosecutions might occur, and they're not necessarily obvious. So, for example, if you're a regulator looking to enforce some action, it may be that you take action against the individual who is... Can you hear me now, John? It may be that you take...
Sorry, thanks. Yeah, my NBN just dropped out for no bloody reason. I warned you.
No, I understand. So, look, I kept going.
It's good when it's good, but it just drops out like for no reason whenever it wants to.
Yeah, no, I understand. All right, so I just mentioned that when you're looking at taking action, think about the possibility of issuing proceedings against people that provided the approvals. For example, a good case on that is Gerhardt and McNeil. It's a decision of His Honour Judge Devereux in the District Court. It came by way of an appeal from a magistrate. And in that case, the building certifier, Gerhardt, was a person who issued a development permit for accessible development. It was to do with a house, but didn't do so in circumstances where the necessary approvals had been given. So the work was contrary to the planning scheme, and the court upheld the conviction and upheld the entitlement to impose a penalty against the certifier. So as a regulator looking for a way to take action against something that you perceive to be wrong, think about taking action against the certifier and not just the landowner. All right. Bear in mind, of course, that if the regulatory authority does issue a notice as a result of being dissatisfied with sentence, there are issues to do with the way in which a court will deal with an appeal. And it's not just a case of the appeal court saying, well, we would have done something different and therefore we'll uphold the appeal. The only basis upon which the appeal court can overturn an appeal or a sentence at a lower court is if the sentence is both manifestly inadequate and the sentence was not reasonably open to the originating court. Okay, and the final thing that I'll talk about tonight, it's only a short session, is have a look at section 437 of the Environmental Protection Act, and it provides the dichotomy between taking action against someone who willfully and unlawfully causes serious environmental harm, which is in subsection 1, as opposed to someone in subsection 2 who unlawfully causes serious environmental harm, and the penalties because of the willful or not necessarily willful nature of the incident are reflected in that change.
Is that the part like back from early in the term where they've done things in good faith and damage has been caused?
Yes. So one thing you can consider by way of a defence is something to do with, for example, the general environmental duty. So if a person attempts to show that the harm occurred while they were lawfully conducting an activity, and in doing so they fulfilled their general environmental duty, that's a defence, that's section 319. Another one, John, might be the issue of due diligence. Have a look at section 493 of the Environmental Protection Act. So where an executive officer attempts to demonstrate that they took reasonable steps to prevent the environmental harm, then that's a defence to criminal law proceedings. And those defences under section 319 and 493 of the Environmental Protection Act supplement the more general defences available under the Criminal Code, section 24, honest and reasonable mistake of fact, and section 25, which is emergency or something that was outside the control of the offender. All right, so tonight the message is that if you see something as a regulatory authority that you're not happy about, you have to think about whether we're going to deal with it administratively, by civil action or by criminal action, or a combination of those three things, bearing in mind that section 24 of the of the Environment Protection Act provides that the Act does not limit any civil right or remedy that exists apart from the Act, common law or otherwise. Yes, John?
This person that's in a regulatory role, is that like somebody that's on the council? And does then the action then become the council's action or this individual person on the council?
Actually, that's a really good point. So when I talk about regulatory authorities, I'm really talking about the executive generally. In the case of Gerhardt, which was where action was taken against the building certifier, it was in the name of the individual complainant, which in that case was McNeil. In the case of let me just see if I've got some notes here. Yep. In terms of the Link Energy case, which dealt with the issue of warrants, that was the CEO of the EP, the Environmental Protection Act. So it can change. Often you'll see prosecutions that are commenced actually in the name of the council. So, for example, there was a case of Rockhampton Regional Council against Dubois, which is 2014 decision, and that was Judge Searles in that case, and it was to do with contempt action. So that was in the name of the council. So it's a very long answer to your simple question, and the point is that it can vary depending on the circumstances.
But that would, sorry, John, that would really change it though. I mean, an individual person on the council will think something's been done wrongly, as opposed to the council with all its resources mounting the same action is a different thing.
Look, quite often it's just a matter of, true, but quite often it's an individual within the organisation that is the named person. So they still have all the resources behind them, but that's just an issue of horses for courses. But very often you actually do see the council as the complainant, even in issues to do with offences. So, for example, have a look at the Brisbane City Council against Stapleton. In that case, there was an issue to do with prosecution for offences, and in that case, the Judge Rackerman decided that the Penalties and Sentences Act did apply for issues to do with contempt. But that was an action brought by the Brisbane City Council. I guess just
last question. I note on your end of your lecture notes this week, exam advice about how many questions and what they may look like as a format. So I guess that 20 marks for the first question is some type of essay. And the 3 questions out of 5 for the last 30% are also essay type questions.
From memory, the first one is a problem-solving question, and I think that there are 2, and again from memory because it's a while since I wrote it, but I think, and this is for 11046, from memory there are 2 essay-style questions and 2 problem-style questions in Part B. But we will have a special session on that later in the course, so I think probably in week 12.
The exam is at the same time in week 12.
Oh, it is? Okay. Well, we better do it next week then. So, all right, next week we'll be talking about it.
Week 11?
Week 11, yes. Okay. So next week we'll talk about that exam. I'll make sure that it's foremost in my mind.
So there is a session next week, but there is no session week 12, or there is a session once the exam is started?
No, I really can't have a session while the exam has started. So I think the exam starts at 6 o'clock. So probably half an hour before our normal session commences. So we won't have a session in week 12. So next week we'll wrap it up, and next week we'll deal with any exam issues, and that's to do with 11046.
Yeah, I'm good.
All right, great. Well, thank you very much, John.
One thing I want to comment on, I should probably put it under your red button, but I like the idea of the oral feedback on the assignments. Out of all the subjects I've ever done, 50 odd, that's the first oral feedback I've ever received on any subject. So I think it's a good thing. Not that comprehensive, but at least it's sometimes you get nothing.
Oh, thank you. I've tried, as you might expect, a number of different ways of providing feedback, and I've started doing that in the last couple of years. People have responded to it in a positive way. I think they see it as more personal, and I can, by using my voice, I can provide a little bit more information as opposed to what's written. People can sometimes maybe misconstrue.
The problem with the course has been your technology. I mean, even that oral feedback, it's a little scratchy. It was audible to me, but some people on the list noted that they couldn't understand what they had, but I could hear what it was. But similarly, even your lectures like this evening, they suffer technological issues.
Yes.
Yeah.
And I don't know, it does seem that my internet connection here has suffered in the last year or two. I'm now encountering difficulties that I didn't encounter previously. So that's something for me to look at. But thank you for that feedback, John. I appreciate it. All right, well, next week, 6:30, and let's see how many people we get along. All right, thanks again. All the best. Bye.